Hello, my name's Olurotimi Osha. I like to talk about American presidents, and I'm doing this video in honor of Black History Month. I've been doing a number of videos, and I want to sort of depart from the apparent doom and gloom in the argument of structural racism and of the past 400 years in America, and focus on a positive aspect of the dismantling of a pillar of racism in America, and that's the anti-miscegenation laws. I mentioned how the first anti-miscegenation laws were passed in the from 1661 in Virginia, and also in Maryland, and they strengthened slavery, and they went on to become law in about 28 states. By in the 1920s, there were anti-miscegenation laws in all southern states, and of course there were and in other states as well. Now, um, as a reminder, of course, our only Black American president is a product of an interracial marriage, and President Obama was born in around 1961. Before Loving versus Virginia in 1967 was declared anti-miscegenation laws unconstitutional, right? But something we don't often refer to is a law that came before Loving versus Virginia. Now, Barack Obama's parents um, were constitutionally married because they didn't have anti-miscegenation laws in Hawaii, where President Obama was born. President Obama was born in Hawaii. Not all American states had prohibited anti prohibited interracial marriage or interracial relationships. It was the southern states that particularly were notorious for anti-miscegenation laws. So today I want to talk about another law, McLaughlin versus Florida, which overruled the laws against cohabitation. Uh, so it wasn't just interracial marriages that were banned by these anti-miscegenation laws, but they also had made sure that there was no sexual intercourse, there was no cohabitation, and in some states, cohabitation was actually a felony as well. So, so I'm going to discuss, two cases, right? The law that went all the way to the Supreme Court in 1883, where the Supreme Court, U.S. Supreme Court, actually said that, state imposed anti miscegenation laws were actually constitutional and did not violate the 14th Amendment. That's Pace versus Alabama, right, in 1883. And of course, I'm going to discuss the subsequent case that overturned it. That's McLaughlin versus Florida. So a reason why, in fact, McLaughlin versus Florida, I find it interesting again because uh, Justice John Marshall Harlan, who had a mixed race uh, half brother who had been born a slave, that's Robert Harlan. I've discussed this before in earlier videos when I was discussing Plessy versus Ferguson. He was on, he was on the court as well, and he gave a concurrent opinion that's agreeing with the unconstitutionality of laws against cohabitation between a black man and a white woman. So it's again, the dismantling of anti-miscegenation laws in America, and where we are today, it's a sign of progress, that progress can be made in the U.S. in dismantling structural racism, because anti-miscegenation laws were a huge part, a huge pillar um, of institutionalizing racism, right? Um, and it's kind of funny. I thought this was interesting because today we've gotten used to interracial relationships and marriages in Hollywood and pop culture, right? Everybody knows of the famous interracial marriage between the Kardashians and, well, Kim Kardashian and Kanye West, and it goes on. And was it the sister Khloe Kardashian and Lamar Odom, the former NBA star, and it goes on. Of course, so interracial relationships are very common in America and internationally now. I remember Seal. Seal is of course Nigerian descent and Yoruba as well. Seal, the artist, the musician, who's British, right? He's British Nigerian. Of course, he was famously married to Heidi Klum, the supermodel, the German supermodel. They're not Americans, but they were living in America. I think they still do live in America. Well, they're international stars, globetrotters, as musicians, as celebrities, often are of their stature. They live everywhere. So, and something else that made me want to do this video, they have this discussion. There's a friend who said something. He's he's Caribbean, and he said this tongue in cheek, and he said, "Hey, why do Nigerians like to marry white women?" I'm like, Nigerian men? What do you mean Nigerians? It was like, that Nigerian men. Why do they like to marry white women? And I didn't have an answer, but I suppose the Nigerians don't, they don't discriminate. We're a very diverse nation. We have over 300 tribes, and in Nigeria, the different tribes. Again, tribe is proxy for race in Nigeria. The different tribes intermarry, right? Over 300 different tribes are in Nigeria, and they all intermarry one another. So I guess Nigerians are just used to not being discriminatory in terms of relationship selection, partner selection in relationship, preference or whatever, right? Choices, relationship choices. So, and interestingly though, I realized I have many cousins in America, and all of my married male cousins are all married to white women. So it's kind of interesting that, hey, and so, but I guess everybody owes this to the cases I'm going to discuss, and of course, Loving versus Virginia. I'm not going to discuss Loving versus Virginia today, but I wanted to discuss these other cases that nobody talks about. So let me start with the case of Pace versus Alabama, right? So in 1881, Tony Pace was an African American man, and this was in Alabama, and um, he'd been he was arrested uh, because of his relationship with a white woman named Mary Cox. Now, while they were not married, uh, there were anti-miscegenation laws in Alabama, and it made it a felony for members, member uh, of for a black man to be in a cohabiting relationship or marital relationship with a white woman, and vice versa. That is, for a white man to be in a relationship or cohabiting relationship or intercourse or marital relationship with a black woman. So it was a felony. So the punishment was a minimum of 2 years, no more than 7 years. It was a felony in Alabama. So for some reason, although these two people, Tony Pace, the black American man, and then the white woman, Mary Cox, although they weren't living together, but for a long time they would travel, they had a meeting place where they had a meeting place where they had a relationship, intercourse, and I guess it was known in the community. It was in North Mobile, not far from their place. So they were arrested, and they were tried and convicted. They both had to spend 30 days. No, no, sorry. They were both tried and convicted and then sentenced to 2 years in state penitentiary. That's the case of Pace versus Pace versus Alabama. So they were both tried and convicted and sentenced to 2 years in prison. Tony Pace, so they would appeal the case to the Alabama Supreme Court, and this was in 1883, right? 1883. They appealed it to, and I'm thinking that, hey, that Black American Tony Pace in Alabama, it was a good thing it wasn't lynched. But in any event, he appealed to the Supreme Court. Of course, this was a time that they had protection from federal troops, and when the Republican Party was trying to make sure that Black Americans had equal rights, equal protection with whites, right? And in fact, you'd see in his appeal, Tony Pace appealed to the Supreme Court, U.S. Supreme Court, saying that the conviction violated his 14th Amendment, equal protection of the law's rights. But before it got there, it went to the Alabama Supreme Court. The Alabama Supreme Court upheld the conviction, saying, well, called it an evil, right? It would, disparaged the relationship as an evil tendency that would lead to, and this is not to be offensive. I'm a historian, but just to show how far we've come. This was in the 19th century. The Alabama Supreme Court used these racist, disparaging, odious words. This was the Supreme Court of Alabama saying that the evil tendency would lead to the creation of a mongrel population of a degrading civilization, right? This is just horrible. And so for the Supreme Court, for the Alabama Supreme Court, it wasn't so much as the interracial sex that they were having, the sex between the black man and the white woman, but the fact that there was a possibility that the interracial sex could lead to the birth of a mixed race child, right? And so that's why the Supreme Court said it could lead to a mongrel population of a degraded civilization. And so see how racist they really were back then in the South. So this was in Alabama. This was 1883. This was what the Supreme Court justices in Alabama wrote in their opinion. So in any event, Tony Pace appealed to the U.S. Supreme Court, that saying that it violated his equal protection of the law, 14th Amendment equal protection of the law. The Supreme Court, ruled in, affirmed the Alabama Supreme Court, saying no, it didn't, finding against Tony Pace, saying that, well, because the punishment was applied in equal measure to either race, right? It wasn't like only only black people engaging in interracial relationships were punished, that whites were also equally punished. So it was both the white woman and the black man. They were both sentenced to 2 years. So the Supreme Court said, well, because they were punished equally, it didn't violate the equal protection of the laws. And they thought that, well, that the state had the states had the power, the police power, to create and enforce such anti-miscegenation laws, right? It was part of their police power. Remember, even till today, the states are supposed to have a police power to create laws regarding health, public safety, and and family. So the Supreme Court viewed it as part of that the creation of the law, the anti-miscegenation law by Alabama. It was consistent and within the purview of their power, their police power, and they also said it didn't violate equal protection of the laws, the 14th Amendment, equal protection of the laws, because both whites and blacks were punished, had the same punishment for engaging in interracial relationships. So you can see how court decisions can be very subjective and confusing, right? How they sort of move back and forth. Now, you would find that later on in McLaughlin, so let's go back to the McLaughlin case this was a 1964 decision, McLaughlin versus Florida. It made it all the way to the Supreme Court. But before that, what happened was a guy called Dewey McLaughlin was a black man, but he was originally from Honduras. He was a hotel porter working in Miami Beach, and he had a girlfriend, a woman he was living with. She was a white woman. Her name was Connie Hoffman, and they'd been living together. But it turned out she was the one who was renting the apartment, and she rented the apartment originally, but the landlady didn't realize that she would bring another man, to be living with her. So when the landlady found out that she was living with a black man in an unmarried relationship, she asked them to leave, but they didn't. And then she decides to snitch and, report it to the police. And the police started investigating and, discovered that, okay, hey, that they were unmarried, and, that the black man and the white woman were living together. And so they eventually arrested them and charged them with, the crime of a black man cohabiting with a white woman. And so they were tried and convicted. They're convicted each to spend 30 days in a county jail, and they were fined each for $150. In today's money, 2025, today's money is that's equivalent of $1,500. The actual statutes, the penalty in the statute says that for a cohabiting relationship between a black man and a white woman, they were to spend not more than 12 months in prison, and a monetary fine of not exceeding $500. So they sort of got off lightly because they were only sentenced to 30 days each in jail, and then $150 each as a fine. However, they appealed it and eventually made it all the way to the Supreme Court. This time, however, and Justice John Marshall Harlan was on the court, and he was in concurrence. They overruled the Alabama court. They found it unconstitutional. So, however, what they found unconstitutional was, so they reversed the verdict, the conviction. What they found unconstitutional was the cohabitation, right? The law against cohabitation. Because again, this is very important. Courts decide on, that's Article 3, courts decide on uh, cases or controversies, right? So there has to be a dispute, and you bring a dispute to them. They don't make advisory opinion, and they don't rule on hypotheticals. So, and they will only address what it is you bring before them. So the parties did not bring the law of interracial marriages. The law, what they challenged was the law against cohabitation, that they were living together, that the cohabitation between a black person and a white person of the opposite sex. So the court said that cohabitation, the law against cohabitation, was unconstitutional. So it was a step and precedent towards Loving versus Virginia in 1967. The Loving versus Virginia is a better known case, which overruled the law against interracial marriage entirely. But this decision in McLaughlin versus Florida, what it did was it said the law against criminalizing interracial cohabitation was unconstitutional. And what the court said in their opinion, they said, well, that it was not possible, for any state to make a law that would criminalize an action based on race, it would be against the Constitution, right? It would be unconstitutional for a state to make an action criminal based on race. So that was going back to the 14th Amendment, right? The 14th Amendment, which in 1883, the courts had made an opposite decision. So now in we find that in 1964, the Supreme Court was now making the proper decision. And again, the Chief Justice was Earl Warren, and again, Justice John Marshall Harlan, who uh, was it 1964? Was John Marshall? No, sorry, John Marshall Harlan was not on. Couldn't have been on the court then because he was on the court in Plessy versus Ferguson. So maybe there's another John Marshall Harlan, his son. So let me I need to clarify. I think John Marshall Harlan may have been on the case in 1883 in Pace versus Alabama. That was probably where um, it was probably his son because there's several John Marshall Harlans. There's a John Marshall Harlan II because I noticed there was a John Marshall Harlan in the decision. It was a John Marshall Harlan decision, but I will correct that. So I apologize for the mix-up. I remember as I was seeing the opinions, I noted what John Marshall Harlan had said. So it was probably, if it was 1964, it would probably have been, it would probably have been his son because John Marshall Harlan would not have been around again. Plessy was 1896. He was around in 1896. John Marshall Harlan had another descendant, John Marshall Harlan II, I think, who was also a justice on the Supreme Court. Um, so in any event, the court said, the Pace versus Alabama was unconstitutional. It overruled the decision in Pace versus Alabama, which had uh, you know upheld you know laws prohibiting interracial cohabitation and interracial intercourse. But now, in McLaughlin versus Florida, the courts were saying, well, it was unconstitutional for um, for there to be for there to be a state law criminalizing an action based on race. And so um, uh, laws against interracial cohabitation were overruled, and eventually that would be a step towards Loving versus Virginia in 1867, which overruled anti-miscegenation laws. Interestingly, though, in Alabama did not um, repeal its anti-miscegenation laws until the year 2000. So it didn't repeal its anti-miscegenation laws until after I had arrived in Alabama and I started living and going to school in Alabama. So that's kind of interesting. So maybe that was the reason why my mom had cautioned me when I was going to Alabama. So but in any event, um, we've come a long way, and there have been a lot of Americans have made a tremendous amount of progress um, in dismantling racial laws and laws that had a tendency to dehumanize Black Americans, keep them subordinate, and cause division between the races. I'll stop here. My name is Olurotimi Osha. I'll keep you posted. Thank you.